Welcome back, everybody. When we first started planning for this workshop, the topic you're about to hear next is the first thing that came to mind. Asian Americans have long been portrayed as quiet, compliant, not troublemakers. But Asian Americans did put up a fight long before John Lewis encouraged us all to make good trouble. The fight is often a lonely journey, but the result benefited all Asian Americans today. We cannot think of a more qualified speaker to present this segment than John Trasviña. Adam, take it away.
Hello, everybody. Good morning for those of you on the West Coast and Midwest, and on the East Coast, good afternoon. My name is Adam Cuby. I'm a social studies teacher in Daly City, California at Jefferson High School. I teach government and economics, and the next speaker and the topic that you're seeing here speaks to a lot of the stuff that I do in my classroom, and I'm really excited to hear him. The next workshop is Asian American legal cases that shaped the civil rights for all. This is a very important teachers workshop session that will build upon the foundational introduction to ethnic studies, which we're actually piloting at our school this year with landmark, but what not widely known legal cases initiated by Asian Americans. This workshop will examine 4 important cases that address segregation, equal protection, immigration exclusion, and naturalization, issues that continue to have an impact on the events today and the identity of Asian Americans in America. EJ put in the chat the Jamboard, and as a teacher, we usually start off with a do now, and I would hope that you guys can jump in here. The prompt is, what are wonderings, questions, and thoughts and feelings that you have going into the presentation that Sandra and I just introduced? And I'm interested to hear, and I bet John is interested to hear, all the teachers here, what are some of the things that they're thinking about when they hear this topic? The timeline of events and milestones and events and context. So I'm going to give a minute or so for those of you to try to put some wonderings, questions, and thoughts and feelings into the Jamboard. So if you can do that, thank you for throwing that back in the chat. And if you don't have any wonderings, questions, or thoughts or feelings, and maybe those will come up during the presentation, I'm going to go to the next slide on my screen. As John's going over these court cases and the information and content that you're going to be hearing about, maybe you can kind of answer this prompt and kind of keep things going. So when we come back at the end, we can kind of reflect on what we've learned. Is the content covered in today's presentation content you already covered in your class? Or is this new content, but it links to the content that you're teaching? And we have middle school, we have elementary school, we have high school teachers, language teachers, social studies, English. We have all different people, and we want to see really how you're going to take the information and bring it into your classroom. So without ado, I'm going to introduce John, and I've worked with him for many years now, and it's really my pleasure to introduce him. John Trasviña is a board member, been a board member for the 1990 Institute for a while. His background is too long for me to give you. I mean, the CV you can see in the bottom here, but most importantly, he's a civil rights attorney that has served under many presidents, President Clinton, President Obama, and President Biden. Just this past Tuesday, he was appointed to the San Francisco Board of Appeals. And I'm really excited to hear his presentation, having worked with him in the past, but this is just information I know is great for my class and will be really helpful. Without ado, I'm going to throw it over to John, and he will take it from here, and I'm excited to hear.
Thank you, Adam. Thank you, Sandra. Good morning and good afternoon, everyone. It's really a delight to be here back with our friends at 1990 and teachers across the country. This is a critically important time, not only for Asian Americans, but also in education. Here in California, as many have noted, we have the California Ethnic Studies, the Civic Seal coming into play in various junior highs and high schools. In Illinois, the first state to pass the TEACH Act, which requires this teaching of Asian American contributions in history, followed by Rhode Island, New Jersey, and other places. So there's a lot to speak of on this topic. And there's many discussions that will be brought about in your classrooms and communities. Our goal for teachers is to help you link the historical content into the current social and political context. For classrooms, it's important for Asian American students to know about their history for their own social emotional learning. But in my view, it's equally important for non-Asian American students to know who else is sitting in the seat of their Asian American classmates, the history, the challenges and contributions of their predecessors. And for those of you who are not classroom teachers, Asian Americans are often in the middle of larger issues and controversies that we will speak about. And often that's not a comfortable place to be in the middle. We will talk about legal developments in the context of a century and a half of seeking to belong. Getting ahead of ourselves, let's go to the next slide. Speaks a little bit of some of my background. In 2 sentences, I've had the opportunity to advocate, legislate, and act on many issues of importance to Asian Americans, communities, and to all Americans. Being from San Francisco, the capital of Asian America, has allowed me to work as a Latino in coalition with Asian Americans as the larger community on many issues. And there are many milestones of Asian American legal history that come right here from our city. Next slide, please. Our goals for today, I've discussed this a bit already. This is not just about history, but about the present day. Some of the anti-Asian violence that comes from a long-standing animosity towards the people and towards the countries of their origins. This is especially true for Chinese Americans fighting off COVID, as well as increased tensions between the US and China today. Some fear the potential of a backlash similar to that faced by Japanese Americans during World War II if war breaks out over Taiwan. And domestically, the outcome of Supreme Court cases later this year and next may also put Asian Americans in the limelight of legal and political discussions. Next slide, please. With regard to the guiding questions, I think it's important for you to take away from this presentation the not well known enough role of Chinese Americans establishing their own legal and constitutional rights, and how these victories have been used to protect others and to advance civil rights generally. We will get into this later and perhaps in the discussion section today. In the Harvard affirmative action case, for example, even the district judge who ruled in favor of Harvard acknowledged that high school teachers and counselors have a stereotypical view that is seemingly held by the larger society. The stereotypical view of Asians not having personality or individuality. It is these teachers who are writing letters of recommendation for Asian American applicants to Harvard that harmed their applications. Now the judge blamed this not on Harvard, even though Harvard elevated the role of teachers and counselors in the student evaluations. She blamed it on the larger society. In any case, understanding where the community has come from and the heroic acts to fight back, starting well over a century ago, can, for teachers and others, start putting these stereotypes to rest and show the struggles and the different contexts than comes out in these stereotypes. It also changes the dynamics of Asian American advocacy, advocating for their own community instead of having to be examined in the context in comparison to others. It's impossible, next slide please, it's impossible of course to cover these subjects and cases in an hour. The goal is to provide you some exposure to the legal history and framework for your class discussions, whether they are for an hour, a unit, or a semester. For that reason, I think it would be fruitful to try not to cover it all, but to open up the time for questions and discussions today. So let's start with some key historical cases on education and then citizenship, and wrap it up with the potential for drastic changes to what we are used to in both of these areas, depending on what the United States Supreme Court does in the coming months. And where have we heard that before? In order to talk about the California Supreme Court case decision in Tate versus Hurley, it's important to set the context for public education generally in that time. California entered the Union as a free state in 1850, and while we didn't have slavery, by 1854, we had segregation, white schools and black schools. Asian immigrants were attracted to California, as we know, by the 1849 gold rush. And then when that dried up, they moved into other areas. They were almost all single men, so schools and education were not really an issue. In the 1860 census, there were only 100 children of Chinese ancestry in the state of California. By 1870, there were 1,500. And that was a high point for the next 50 years. So we look at the impact of the exclusion laws in the 1882 and beyond, it stunted the growth of the community. Very few children, very few families, but there were some. By 1860, Blacks, there were enough so that Mongolians, as Asians and Chinese were referred to, Blacks, Mongolians, and Indians were prohibited by state law from public education. In the 19th century, San Francisco was the largest city in the state, so the local politics drove statewide politics and laws. And similarly, in the 1880s, as California was growing, it was a large and a swing state nationally, so our local anti-Chinese immigrant politics took on national significance in presidential politics and in legislation like the Exclusion Act of 1882. But in 1864, still with very few Chinese immigrants, California permitted separate schools for Black and Indian children. One of the first challenges to separate but equal came 10 years later in a suit against the San Francisco Public Schools, challenging the prohibition against Black students in white schools. This was Ward versus Flood. The state court ruled that Blacks could be educated, but did not have a right to integrated education. However, in the following year, because of costs, it cost too much to have two separate school systems, the schools were basically merged so that the Black and white children went to school together. But what about the Chinese kids? And this is an example of the question that Asian Americans still pose today, or is posed to them. Where do we belong? Elected officials felt that Chinese immigrants didn't fit in. They worked too hard, forced white workers, including immigrants, to compete for lower wages or work in more difficult conditions than they should as white people or Europeans. This was the case in the gold mines. It was later also the case in the cities. Since they didn't, quote unquote, fit in, the mainstream didn't want more of them and put up barriers to starting families, keeping women out, as Professor Hsu talked about with the Page Act of 1875, prohibiting interracial marriages. But there were some families who did enter, typically the families of merchants. In fact, it was those very children of Chinatown, few in number, but there were still some that typically born here. But most of young people, if young people came in, they either came in as children or they came in as young workers. But they were seen as a bridge to the new country. In the U.S., education, again, the context for education for non-whites was not always permitted, and when it was not on an integrated basis. Education for girls was not universal. Even education above 8th grade was not common. When Lowell High School, the oldest high school west in the Mississippi, was started in 1856, it was called Union Grammar School, trying to hide the fact that it was actually going all the way to 12th grade. We had no university system at the time. By the 1880s, and here's where we get to Tate versus Hurley, as author Wendy Roos writes in her very good book, Children of Chinatown, demonstrating an interest in education, good grooming, being more Western, was not only pushed on the children by the various church groups establishing the orphanages for them and quote unquote saving them from all sorts of ills, but it was a response to the anti-Chinese sentiment placed upon adults by mainstream San Francisco, California, and the nation. My former dean colleague, now president of CCNY, Frank Wu, has written, and others have pointed out, that this is actually the origin of the model minority myth. It was designed to show that the Asians were good enough. It was not done to combat, it was done to combat racism. It was a response to racism and not really in the context of other minority groups. Mamie Tate is the 8-year-old whose parents wanted her to go to Spring Valley Elementary near their home. She was denied entry because the San Francisco schools believed that Chinese children should not receive a public education. The superintendent pointed out that the state law said all children could go to public school, but there were exceptions for filthy and contagious students. Article 19 of the California Constitution said it was the state's responsibility to try to keep Chinese out. So that according to the San Francisco schools, why would you allow public education for the children when the goal is to keep people out? The superintendent acknowledged the Chinese very much cared about education. He said in the letter to the school board that they would lie about being able to go to school because they wanted education so much. So making sure that Chinese kids didn't have an education was a key part of keeping Chinese out. Also, they said that the 14th Amendment was only for blacks and not for Chinese. Now, Mamie, despite that, her parents went to court and they won at the district. The district court ruled in their favor. The school district appealed to the state Supreme Court, and the state Supreme Court ruled for Mamie and her parents, upheld her right to an education in San Francisco because there was no national origin bar to keep her out of the public schools. But the school district, again, another theme is the school district wanted the last word. So they said, okay, maybe we have to admit her, but we don't have to admit her to the same schools as white children. And they established the Chinese school. This decision outraged her mother, Mary. She wrote to the Board of Education. Mamie spoke English, had white friends, had a white last name. They were middle class and wore Western clothes. And she wrote that these Christian men on the school board go to church every Sunday. They still look down on her. To quote her letter, it seems no matter how a Chinese may live and dress, so long as you know they Chinese, they are hated as one. There is not any right or justice for them. So this is another example of Chinese doing everything they can to belong, and it's still not good enough for the mainstream society. A few years later, Dr. Wong, in 1903, Dr. Wong Him, his 8-year-old daughter, Katie, was sent home from Clement Grammar School in the Richmond. Now, here's a rare case where Chinese were allowed to live outside of Chinatown. So she was going to school in the Richmond district, but she was forced to go to the Chinese school in Chinatown because white parents objected to having her go to school. So again, Dr. Him's case was making the case that he as a doctor and his family outside of China was different than the downtrodden kids in Chinatown, but to no avail. In Wong Kim versus Callahan, in the federal case, the federal court ruled that education was a state matter, which is an important legal trend, and would not find that Katie's equal protection rights were violated. Shortly after these cases, as the immigration patterns changed, the San Francisco School District created an international incident, this time by attempting to prohibit the newly arrived Japanese immigrant school children. Families went to the local Japanese consul here in San Francisco. He went up his bureaucratic ladder to the highest levels of the Japanese government, who then complained, but they didn't complain to the school board. They didn't complain to the mayor. They complained to President Roosevelt. And President Roosevelt summoned the San Francisco School Board to Washington, D.C. They backed down and they allowed the Japanese students into school. This represents another theme in Asian American legal history, the role, either weak or strong, of the relationship of their country of ancestry with the United States. When it's weak or adverse, even native-born Asian Americans suffer, with the most obvious example being the internment of Japanese American citizens during World War II. And at the same time, when it is strong, or in contrast, when it's strong or advantageous, we see the communities being protected. President Theodore Roosevelt was confronted with a treaty violation by the San Francisco schools and wanted to make sure that Americans in Japan were treated fairly. Later on, we had the repeal under President Franklin Roosevelt, we had the repeal of the Chinese Exclusion Act in 1943, not because of domestic politics, but because of our wartime allyship with China. In the 1950s, Chinese Americans faced harassment locally because of FBI's anti-communism work, again, an international issue. And the '65 Immigration Act was primarily a result of foreign policy politics, East-West competition over non-aligned countries in Asia and Africa, and much less a result of the domestic civil rights movement. I know there was a question about that in the earlier board, and that's another topic of current conversation. But back to education and the beginning of the 20th century, access to education was the first step. As we know, Plessy versus Ferguson reinforced at the national level the doctrine of separate but equal, until Brown versus Board of Ed in 1954. In the intervening years, an important case came from an appeal in 1927 from the Mississippi Supreme Court. And that's it. That's the case you see on the slide now. Martha Lum lived in Bolivar County, which is the way Bolivar is pronounced in Mississippi. Bolivar County had a separate white school in the district. They had a system of white schools and colored schools. There was a so-called colored school. It was in the county, but it was not in her school district. Her father, Gong Lum, wanted her to attend the white school because it was closer, and argued that she wasn't Black, so she must be white. So here again, you have the question of, well, where do Chinese belong? In a Black-white society, not an issue of whether she's an American or not, but if she has a choice between white or Black, or being not white or not Black, where do Chinese belong? In these cases, while the tapes had argued that the daughter was similar to and just as good as white children, Dr. Wong Him, had said his daughter didn't fit in with other Chinese children. Gong Long had to face the U.S. Supreme Court had already upheld separate but equal, and was only left with the argument that the placement of his daughter was incorrect. She should go to the better white schools than the schools set up for Black children. This was the forerunner to the separate is not equal argument that prevailed in Brown versus Board of Ed 2 decades later. The Supreme Court dealt the Gong Long family 2 defeats. They maintained that schools were state and not federal matters, so they wouldn't want to touch it. And second, they said that Chinese, as a matter of law, were not white and belonged in the so-called colored schools. The court pointed out in the 1870s, when, as a result of the Civil War amendments, the naturalization was expanded. The legislation used to expand naturalization, originally the first version of it said, no longer is naturalization available for whites only. They then realized that, well, that would allow Chinese to become naturalized, and they didn't want that, so they went back and said, naturalization is for whites and for people of African descent. The final education case I'd like to share with you comes to the U.S. Supreme Court, again from the San Francisco Unified School District. This is a mid-20th century case. It did not establish a federal constitutional right to education. Again, the theme about what's the federal role in education, but it did open the door to increased federal court involvement by way of the 1964 Civil Rights Act that barred discrimination by recipients of federal funds. So here you have use of the 64 Civil Rights Act on education, Chinese Americans in San Francisco leading the way for it to be used to benefit everyone. In this case, it was brought on behalf of 1,800 Chinese American non-English speaking students residing in our Chinatown. They argued that San Francisco's failure to provide instruction, taking into account that they didn't know English, denied them a meaningful opportunity to participate in the educational program. All the earmarks of discrimination that was prohibited by the Johnson and Nixon administration regulations that required school districts to remedy student language deficiencies. The court stated that San Francisco's position made a mockery of the requirement to learn English and have instruction equally available to all students because the kids didn't know English at all. It was a unanimous decision, although Justice Stewart in his concurrence wrote that he could not understand how 1,800 Chinese American children in San Francisco could not speak English. And he warned that his concurrence was not an endorsement of this instruction requirement for Spanish or other languages, or in every district where there were only a few students. He felt it was constrained to San Francisco, but he was only one member of the court. The Lau decision actually paved the way for school districts across the country to take affirmative steps to teach non-English speaking children. Many methods and many shortcomings. There are still many children who need it across various communities, but the Lau decision, not only did it expand bilingual education, but it also expanded the view of non-English speakers into the Voting Rights Act of '75 to provide bilingual ballots, bilingual health services, public information, private sector services. So the growth of bilingual services and multilingual services today comes in large part through the Lau decision. But just to demonstrate that the Chinese American community is not monolithic, Kinney Lau himself the 9-year-old who was the subject of who was the Lao of the case, 10 years later, he was quoted as saying that the decision required too much and that having instruction in your own non-English language would impede your acquisition of English. So the consistent themes here are Chinese Americans' role in advocating for themselves has been lost to history. Many of these people you haven't heard of. Second, Chinese American legal victories had an effect on and helped other communities. And third, Chinese Americans had varying tactics and strategies to show they belong. Now I'd like to turn to two 14th Amendment cases, Yik Wo versus Hopkins and U.S. versus Wong Kim Ark, that highlight these themes as well. Now you're probably expecting me to say that Yik Wo belongs among the long forgotten heroes of 19th century Asian American civil rights. Actually, I can't say that. Yik Wo was the name of the laundry shop. It was Sang Lee who was the owner. His name has sort of been forgotten in place of Yik Wo, but Sang Lee was the owner. He was arrested for operating his laundry in violation of one of the many anti-Chinese ordinances passed by the San Francisco Board of Supervisors in the 1880s. After working in the mines and railroads, Chinese immigrants returning to a growing San Francisco, more immigrants came to the U.S. as contract laborers. They were a perceived, and some would say actual threat to the lifestyle of the European immigrants who didn't like the economic competition or the Chinese people or their customs. Unions formed the Working Men's Party and took over San Francisco local politics, which, as I said earlier, had a large impact on state politics and then internationally for the rest of the 19th century. 145 years ago this week, the San Francisco riots of 1877. 4 Chinese were killed, 20 laundries were burned. This riot politicized a member of the Pickaxe Brigade, a young man by the name of Dennis Kearney. Dennis Kearney would become probably the most anti-Chinese activist of his time. City officials looked for many ways to drive Chinese immigrants out. While they could not do so, they worked hard to make life difficult for Chinese residents through local economic and social prohibitions. The Q Ordinance, prohibiting the long ponytail for men. The Cubic Air Ordinance, which was described as promoting safe living conditions, but in fact simply targeted Chinese who lived together in close quarters. Laundries continued to be one of many ways in which European immigrants competed with Chinese and which gained special disfavor with the Board of Supervisors, which passed ordinances at the rate of 1 new fine per year against Chinese laundries from 1870 to 1884. The Chinese laundries were a little bit different from non-Chinese ones. They used poles to deliver their wares, so it was easy to target the Chinese laundries for additional fines or prohibitions. Local officials also said that when Chinese laundry workers blew into brass tubes to form steam for ironing, that they could pass diseases on to their customers. So again, they used the health reasons, which became very, very diabolical at the turn of the century when the Black Plague came to San Francisco. But in 1885, Sang Lee and every Chinese laundry operator was denied a license. In defiance, he kept his store open. He was fined and then imprisoned 6 months for not paying the $1,000 fine. Like Rosa Parks, who was a civil rights organizer the day she sat in the front of the bus, Sang Lee knew what he was doing. He had the backing of his association. They hired lawyers to defend him, and he challenged the ordinance on behalf of 150 Chinese laundry owners. His case went to the California Supreme Court, but he lost. But there's one more place to go, the United States Supreme Court. And even though this was not necessarily an era where the Chinese, where the court was ruling for Chinese Americans, on the front steps of the court, when you walk up, you see etched in stone, equal justice under law. The U.S. Supreme Court agreed with Sang Lee and overturned his arrest and fine and struck down the San Francisco Ordinance, using the Equal Protection Clause of the 14th Amendment. The court ruled that the denial of equal protection of the law applied to more than explicit racism. The equal protection guarantee also protects individuals against disparate treatment, or as the court stated, the naked and arbitrary power to withhold consent. San Francisco's law did not distinguish between Chinese and non-Chinese owned laundries. If you read it, you wouldn't see any reference to Chinese. but yet of the 320 laundry permits in San Francisco, not one was granted to the 240 Chinese applicants. And every non-Chinese applicant, except one, was granted a license. So the equal protection clause is critically important. The local laws didn't have to say no Chinese need apply for a license, but the message was very clear. This was the first time the court looked beyond the text of a statute or a requirement to the conditions of things as they existed and found an arbitrary classification that achieved a discriminatory outcome despite it being silent as to race or any protected category. The Yiquo decision is important for many reasons. It helped establish the 14th Amendment applied beyond the African American community to include other races. It helped establish that the 14th Amendment applied to business regulations. And today, civil rights advocates routinely cite the Yiquo decision in challenges to statutes, regulations, and practices that have a disproportionate harm based on gender, race, national origin, religion, sexual orientation, and other categories. Courts apply what is called strict scrutiny to these laws, and they are often struck down as violating the Equal Protection Clause. We can date that back to the Yiquo decision and Mr. Sang Lee. Next slide, please. Wong Kim Ark. Now, Wong Kim Ark is truly an American and truly an American hero. Almost 125 years later, from his 1898 case, it is still not known well enough, but it should resonate with your students. He was a cook and laborer in his early 20s in San Francisco Chinatown when he was denied entry into the United States. The earlier cases that we talked about dealt with school children, and we remember them because their names were in the cases. But it's really their parents at risk who risked a lot. In 1998, when I served in the Justice Department, leading the federal government's only office focused solely on immigrant civil rights, I partnered with the Asian American Bar Association of San Francisco to recognize the Wong Kim Ark case centennial. We held an event at the Chinese Consolidated Benevolent Association, also known as the Six Companies. Their 19th century counterparts organized Wong Kim Ark's legal challenge to being denied entry. We were joined in 1998 by Mayor Willie Brown, supervisors, and representatives of the state. Mayor Brown observed that all the institutions that had lined up against Wong Kim Ark and the Chinese American community a century before were now celebrating the decision. So in your classroom discussions, I think it's important to balance how far we have come with how far we have to go. Wong Kim Ark was born in 751 Sacramento Street in San Francisco in 1873, on the second floor above his father's shop, 5 years after the ratification of the 14th Amendment. The 14th Amendment that promised that all persons born or naturalized in the United States and subject to the jurisdiction thereof were U.S. citizens. He and his parents left the U.S. for China in 1877, right after those riots that I mentioned to you earlier. He went back and forth a few times over the years, and on one return trip, when he was about 22 years old, he was prohibited from entering on the basis of the Scott Act of 1888 that prohibited the entry of Chinese laborers, even those who had reentry permits. Now he responded, "I'm not coming back. I'm not coming in, I'm coming back." Wong Kim Ark was a San Francisco native and thus a United States citizen, not subject to the Chinese Exclusion Act. It was relatively clear that Wong Kim Ark had been born here, but was he subject to the jurisdiction of our laws? I say relatively clear because immigration officials throughout this period of Chinese exclusion routinely required exacting proof of identity and familial relationships from Chinese intending immigrants, and like others in the mainstream society and in the law, generally had a suspicion that Chinese immigrants would lie in order to enter the country. On the requirement that the individual was subject to the jurisdiction of our laws in order to qualify for citizenship at birth, birthright citizenship opponents contended and still contend that his allegiance was to China, the country of his parents' birth, and not to the United States. Now, this would be a no-win quandary for natives like Wong Kim Ark. His parents were barred from becoming U.S. citizens, and it's difficult, so they couldn't claim allegiance to the United States, and it's difficult for an infant literally an infant, to demonstrate any kind of political allegiance. Children, if the opponents had won, children born to immigrants under this reading of the 14th Amendment would be deemed citizens of their parents' country, even if that was their only connection to that country. And worse, if their parents' country did not recognize foreign-born children, then they would be stateless. Now, nations typically grant or recognize citizenship in one of two ways: just sanguinis, by the blood or citizenship of their parents, or just solely, by place of birth. The U.S. Supreme Court answered this question clearly in the Wong-Kim-Ark case. The terms of the 14th Amendment were just exactly what they said they were. Born in the United States, you're a United States citizen. They traced back the origins of the 14th Amendment, the Constitution, the formation of the colonies, all the way back to the 1608 English decision in Calvin's case that established that citizenship would be based upon where an individual was born. The 14th Amendment extended that person's principle to all persons, irrespective of color, except for children born in the U.S. whose parents were foreign diplomats, who presumably wouldn't want U.S. citizenship, or occupying soldiers. Indians on reservations were treated separately because they were subject to the laws of tribal governments and not the United States, unless by treaty. Now, the victory for Wong-Kim-Ark was a defeat for anti-Chinese nativist forces in turn-of-the-century California. The San Francisco Chronicle took the defeat philosophically and observed that, well, so long as the state can protect the ballot box, it is safe from the more unpleasant features of Chinese and Indian citizenship. The beneficiaries of Wong-Kim-Ark, the man and the decision, go far beyond those of Chinese descent born here during the exclusion period. Ever since, birthright citizenship has protected children born here whose parents are international students, maybe H-1B, high-tech, other temporary workers, and those whose parents lack any immigration at all, or who for whatever reason have not decided to apply for naturalization. Consider Vice President Kamala Harris. She's a United States citizen born in Berkeley. Her mother and father were foreign students on temporary student visas. They owed allegiance to their home countries until and only if they renounced that loyalty in their eventual naturalization oath. Without the Wong-Kim-Ark decision, as a child, Kamala Harris would have had to choose between being a Jamaican or an Indian citizen. And we do not typically accept the oaths of children, so she would have had a long wait before being declared a U.S. citizen. Since 1898 on to today, millions of people, both here, born here, have the certainty of birthright citizenship and can avoid the impossibility of proving their allegiance. And of course, all persons who are here are subject to our laws. They must follow all local, state, or federal laws, and there's no exemption card for those who are not yet citizens. So in contrast to determining their citizenship based upon the nationality of their parents, looking backward in time, the Wong-Kim-Ark decision symbolically heralds their future in the American democracy and culture. So in terms of the question of belonging, it's not where you came from, but it's where we together are going. Well, now we are going to examine some present-day events regarding these same issues that will be useful to your students to explore why the cases of the past are important today. First is in the area of voting. I mentioned earlier about the San Francisco Chronicle's response on the earlier question of Wong-Kim-Ark, and also it parallels with the state's response on education. Yeah, we may have to allow you into our schools, or yes, you may be citizens, but we're going to make sure it's second-class citizenship, or we're going to make it difficult for you to be here. And that's what happened. That is what has occurred over a period of time. Often a response to these cases. At the end of the 19th century, and when we get into voting, at the end of the 19th century, and the beginning of the 20th century, the progressive reform movements started as a counterattack to political corruption represented to them by powerful railroad and business interests on the one hand, and the urban political machine fueled by the manpower and muscle of new immigrants, and many times their votes on the other hand. During this era, there was no particular link between citizenship and voting. In 1874, the Supreme Court ruled that being a citizen was not a condition precedent to the right to vote, and 9 mainly southern states had constitutional provisions allowing non-citizens to vote. But again, like education, voting was considered largely a state or local issue. Legislatures, we didn't have generally the right to vote for a U.S. senator. Senators were appointed by governors or legislatures. As a way to clean up political corruption, the progressive movement made many changes to our laws, including adding a requirement that the right to vote be for citizens, at least in the state of California. As a result of these reforms, non-citizen voting tended to go by the wayside, and it was largely the issue has been largely dormant except for the last couple of decades. Until recently, only a small handful of jurisdictions permitted non-citizens to vote only in local elections, and most of these jurisdictions did so not in response to a political groundswell of large immigrant waves, but as an accommodation to unique pockets of foreign-born individuals. A lot of these jurisdictions that allow non-citizens voting at the local elections are in and around Washington, D.C., because they have a lot of non-citizen people who non-political or non-foreign diplomatic or sub-diplomatic embassy staff, scientists and researchers coming to the area. So they have, as a matter of custom, allowed non-citizen voting in Chevy Chase, Maryland, Marshall's Township, and other areas. In the 1990s, a few additional cities, in political response to the growing Latino populations, Tacoma Park and Hyattsville, Maryland, for example, added non-citizen voting to encourage the new Central Americans to have a voice in the schools. After some unsuccessful ballot attempts, San Francisco voters decided in 2016 to share the vote with non-citizen parents, but only for school board elections. Unexpectedly, the election of Donald Trump in the same 2016 election put on ice any concerted efforts to register non-citizens, since local leaders feared that creating the list of non-citizen voters would be accessible to the Trump administration, expose unauthorized immigrants to potential enforcement, and would require even legal residents, when they apply for naturalization, to have to explain how they voted in the U.S. election, even though it was legal. The San Francisco provisions complied with the federal laws, but they were considered awkward and were not well used until the recent recall election earlier this year, when many Chinese Americans, non-citizen parents, signed up to vote. In New York, San Francisco is by far the largest city to have non-citizen voting, until New York City last year went one big step in further by allowing non-citizens to vote for mayor, city council, and other local offices. The New York measure was recently struck down by a local court, and the San Francisco law, despite being on the books since 2016 and being used in a couple of elections since then, was struck down yesterday. So this is an up-to-date presentation. Yesterday, Judge Ulmer struck down the non-citizen voting provision because it violates the California Constitution that says U.S. citizens may vote. San Francisco's argument was that it can expand the electorate. The San Franciscans wanted to share their vote with non-citizens, so San Francisco was owed deference as a charter city. The challengers argue that school districts are really state entities, and if a state constitution says U.S. citizens may vote, there would be no reason to have that provision if non-citizens were allowed to vote. So the court has permanently enjoined the non-citizen voting law in both New York and California. But the issue of non-citizen voting may be one of the best ones for active class discussion. At one level, it's focused on the rights of parents to be involved and have a say in their children's education, something your students should be able to relate to. It raises issues such as taxation without representation, promotes debates over whether an actual parent of a current student should be denied a vote when someone with more distant, if any, current connection to the schools, senior citizens, people who don't have children, they get to vote for the school board. So larger discussion of what it means to be a citizen in the first place. Going beyond Asian American issues or history, is there a civic admission fee for people that people must pay in order to enter the governing world, whether they are born here or not? And what are the civic responsibilities of people before the age of 18? We prohibited poll taxes. We don't require paying of taxes to vote, but yet we're denying non-citizens, tax-paying non-citizens the right to vote. Another case where Chinese have taken the lead is in federal employment. It used to be that you had to be a citizen in order to be a federal employee. Because of the 1975 Supreme Court decision brought by Mo Sun Wong, a San Franciscan who wanted to be a postal worker, U.S. citizenship is no longer required for many federal jobs. Now let's go to the next slide on the future of citizenship and expanding Wong Kim Ark. As I've stated, the Citizenship Clause grants citizenship to people born in the United States or who are naturalized. The Supreme Court answered the question about what the word "in" means at the turn of the 20th century in what are called the insular cases. Specifically, the court decided that in the United States meant the states and not the territories beyond that. So for our territories, Puerto Rico, Guam, Virgin Islands, the Northern Marianas, and American Samoa, let's leave the District of Columbia out of this discussion for a second. People born there are not covered under Wong Kim Ark. They do not have constitutional citizenship. But the Supreme Court in the insular case has said that's up to Congress. Congress can decide. And the way the Congress has decided is that there's some some territories are treated differently than others. So the Jones Act allows Puerto Rico. People born in Puerto Rico are native-born U.S. citizens. People born in American Samoa are nationals. They are not United States citizens. So recently, a man in Utah, John Fitzsimonu, who was born in Samoa, he has a U.S. passport. He objected and he has sued the federal government, saying the Wong Kim Ark analysis, we're born in the United States, it includes America and Samoa as part of the United States, we should have automatic citizenship. And this is a case where the district court in Utah, where he lives, agreed with him, but the government appealed successfully to the 10th Circuit Court of Appeals. And currently the United States Supreme Court is receiving arguments on both sides and considering whether to hear this case in the next term, which starts in October. Again, the case goes to the heart of the continuing question of belonging. In this case, while some in the Asian Pacific Islander communities are reducing the importance of citizenship by limiting the citizen-only aspects of our lives, saying, well, voting, employment, other things belong to citizens and non-citizens. Here's Mr. Fitzsimonu saying, my non-citizen status isn't good enough. I and everyone born in American Samoa should be treated as a citizen at birth. As I said, up to now, it's been up to Congress. The insular cases that have been relied upon go into a lot of racial stereotypes about really the relative level of assimilability of the various people on the territories. They do not. The Supreme Court cases speak very poorly of some people in some territories, but they say they leave it up to Congress to figure out. If Congress wants to grant citizenship, then Congress can do so. Justice Neil Gorsuch, a conservative, is the leading voice on the Supreme Court, saying that the insular cases are wrong, and has asked the court to take up these cases, presumably to extend Wong Kim Ark to cover not only in the United States being the states, but also in the United States being the territories as well. And if Gorsuch, the court is, as you know, split between a liberal bloc and a conservative bloc, Gorsuch could have the appeal and the support of some members of the conservative bloc, and some members of the liberal bloc of the court may also say it's a historic wrong. It's based on cases that are considered discriminatory, and they may extend citizenship to all people born in the United States, to include American Samoa. But here's where we have a problem. For years, many of the same conservatives have sought to limit Wong Kim Ark's application so as not to include the children of undocumented immigrants. Donald Trump ran on this issue, among others. A Southern California law professor who's been in the news lately, John Eastman, he's gained fame as the lawyer behind Trump's overturning the Electoral College strategy. He has written that the Wong Kim Ark court did not address unauthorized immigrants, in part because the concept of unauthorized immigration didn't exist in the late 1800s. So accordingly, there's a tremendous appetite among those who want to restrict granting citizenship to everybody born in the United States. There's a tremendous appetite for them to get Wong Kim Ark back in front of the Supreme Court. Thus, the Fidesamanu case runs the real risk of the Supreme Court using it as a way to pare back Wong Kim Ark. And whatever the merits of his own individual case, and there are good points on each side, American Samoa, the government of American Samoa is against him, for example. It's a very dangerous proposition to give the Supreme Court this opportunity. One could easily see Judge Gorsuch writing a majority opinion that says the insular cases were wrong and based on racist stereotypes. We should extend constitutional citizenship under Wong Kim Ark to people in Samoa. But Wong Kim Ark should not be read to include children of undocumented immigrants. And the exceptions to the birthright citizenship clause apply to the children of occupying soldiers. The court could treat people who came here against our laws like those children of soldiers, and they could rule in 2022 or next year that the court in 1898 either got it wrong or just wasn't thinking about undocumented immigrants. That would not take away citizenship from any individual, but they would say there's no authority unless Congress decides that the children of undocumented immigrants born in the United States should get naturalization, should get citizenship. And there's the logic goes one step farther, is that if people born in the territories, part of the United States, have to rely on statutory citizenship, why do people who are born without any authorization, whose parents have no authorization, get to have constitutional citizenship? So this wouldn't necessarily deny citizenship to individuals, but it would put it back to Congress. And we can only imagine the outcome. Here you have a court that is willing to go beyond what is asked to do. It's willing to repeal and overturn past decisions, leaving it up to Congress in a presidential election year. I don't know when. So I would say that a victory for Fidesamanu could lead to a major change, and unlike the Asian American civil rights cases advancing civil rights, this could be a case where inadvertently they could retract civil rights. Finally, in the amount of time I have left, and before we open it up for your questions and comments, I want to turn to the U.S. Supreme Court consideration this fall of a challenge to the Harvard and University of North Carolina affirmative action programs. I mentioned it a bit earlier. It's been in the news, so I will be brief. I was involved in a challenge to some of the universities' admissions policies on the same grounds in 1990. At that time, my boss, Senator Simon, was chair of the Constitution Subcommittee in the Senate, a member of the Education Subcommittee. He inquired to the Justice Department and Department of Education, along with, in partnership with, Asian American organizations like the Japanese American Citizens League and the Organization of Chinese Americans. At that time, these community groups were very much opposed to the treatment of Asian American students at these universities. The university's response at the time was, well, we didn't do anything wrong, but we won't do it again. And Asian American admissions went up after that because there was systematically showing that Asian American students of the same grade point, the same test scores, were not getting in as frequently, or they were getting in at a lower rate than white students and other minority students. Similarly, now we're at the same factual legal situation, but the politics of it and the concepts of diversity, the concepts of where Asian Americans fit in the spectrum of belonging, whether they are perceived of and in alliance with other minority communities. Some argue that Asian Americans benefit from affirmative action. Others argue the opposite. In any case, it's not my intention to delve into the merits. There are obviously merits on both sides, but this fall the Supreme Court will hear the Harvard case and the University of North Carolina case, and again, you have a situation where this is a court that does not at all hesitate to go beyond what is before them. And they've shown to be no friends of affirmative action. Even Chief Justice Roberts, who many feel will tend to side with the liberal bloc of the court occasionally, he wrote in 2007 in a public school case. He said, the way to stop discriminating on the basis of race is to stop discriminating on the basis of race. The main question, given that the newest justice will not be allowed to vote on the Harvard case because she was on the board of overseers, so that really leaves Justice Kagan and Justice Sotomayor on one side and many of the justices on the other side. I think the main question is how far the Supreme Court majority will go in its decision. Will it take the opportunity to overrule and put into question the use of race and other demographic factors in K-12 education? Will they apply that to affirmative action in employment? So Supreme Court litigants need to keep an eye on the wider impact of their cases. The cases are never about their own issue. Supreme Court gets the last word and can rule expansively or narrowly. We've spent this time focused on almost 150 years of cases brought by Asian Americans that have played a part in advancing civil rights for all in America. In the coming months, the adverse decisions by the Supreme Court could turn back the clock on these advancements, again affecting not just Asian Americans, but all Americans. The outcomes of these cases will once again help shape the discussion on where and how Asian Americans belong in our society. It is the quest for belonging that started from the first arrivals, went through the violent attacks of the late 1800s, the suspicions for much of the first half of the 20th century, and an emergence in the latter half and today, sometimes associated with other ethnic and racial minorities, sometimes more closely with the mainstream. Many stories, one quest. So I hope our time together provides additional insights for the teachers to prepare for fruitful and educational class discussions with their students this coming school year. Thank you very much, and I'll turn this over to Adam or to Sandra to start a discussion and be of whatever service I can to you. I just want to say in a final note that given that there will be many developments coming up in the near term and over the next year, I'll be discussing a lot of this on Twitter. You can find the latest information there, so please follow me there. Thank you.
Wow, John, if your mind was a blank page, it is soiled with information, great information. And I think everybody was so focused on listening to your presentation that they may not have given us all the questions that you can answer live here. So for those who have not sent in your questions, please put them up as soon as you can. I just wanted to, John, if you can address a couple of things here. I mean, you talk about, these laws being put in practice and then eventually can be overturned, as we saw Roe versus Wade, which is an incredible way of turning a decision that was been in place for 50 years. Is there any assurance that some of these laws will stay, or would they be overturned?
That's always the question, and that's where advocates sometimes pull back. And in my own experience, there have been cases on the issue of disparate impact, on the issue of the current application that started with YICWO. People challenge cases based on disparate impact. We felt that sometimes the court might say there is no disparate impact anymore, and rather than going forward on the particular case, people held back. They settled the case. For example, with the Harvard case, it's one thing to disrupt the Harvard affirmative action admissions plan. It's another thing to then have that decision in front of the Supreme Court, which the advocates can't control, who could say, well, not only is the Harvard affirmative action plan bad, so is the one at other colleges and universities, so is using race in any particular aspect in lower levels of education, K-12, and so is using race in employment. So it's a strategic decision of how far you go with your one case, because it has other impacts and other ripple effects. Now, you can always go back to Congress or back to state legislatures and try to repair the damage, but that is very, very difficult. And I would say, particularly on the case of wonky mark not being applied to the children of undocumented immigrants, I don't see a chance that Congress would step in and say, oh no, we really meant that, and it should apply. I think where it would come up was if the Supreme Court did that, then you'd find some of the southern states, for example, or other states denying birth certificates to children who can't prove the citizenship of their parents. And once you say that it's reliant upon the citizenship of their parents, then there's no distinction between undocumented and legal immigrants. There's no basis to say that a foreign student or someone on a temporary visa would naturally get birthright citizenship for their children.
And extending that one step further, that affects a whole group of voters, right? That's a pretty scary thought. I'm going to bring back a question that was posed to Professor Lok-Siu earlier, but I think it's also applied here. It says, how have you addressed the current divisive decision among Asian American students about affirmative action, college admissions, and the push towards eliminating entrance exams at elite public schools? So I kind of referred to the situation in San Francisco of the elite public high school, Lowell High School, of which, John, you are an alum. And also there's a documentary that was put out last year called Try Harder, that talks about the environment of that particular school. But John, can you answer that question in addition to what Professor Locke said?
I'd be happy to give it a try, or at least a start. One of the allegations about Lowell High School that is, candidly, there are too many Asians. It's not said that explicitly, but when the concept of being overrepresented is just that. It's buttressed by the sense that admission tests or testing itself is somehow Eurocentric, or that the merit system is based on whites. Now, maybe in that is itself Eurocentric thinking, because the history of testing, examinations, the history of merit is not limited to Europe. Some would say Europe got it after, and that people just want to do better for themselves. There's also the issues of how people recognize that. Well, we look at the data, and all of the census data and everything is averages. There's going to be people above and below the average for a particular community. So people look at Lowell High School graduates or University of California graduates as the elite, high economic, but they don't look at where they were when they started and the fact that the education got them there. So there's a lot of discussion that needs to be had about educational disparities and the notion that Asian Americans are doing well, therefore their advantage, ignores the very real stories coming from New York for the New York academically selective schools, Boston Chinatown, Boston Latin, Northern Virginia, San Francisco. So there's a lot of discussion that has to be had, and as I said, there's arguments on both sides, and this is what will come out in the Harvard affirmative action case at the Supreme Court.
Thank you, John. That was very helpful. Feel free to continue to send in your questions, and don't forget to fill out the feedback form. Adam, the floor is yours, and you can conduct the curricular discussion. Thank you.
Great. I just want to thank John. I've worked with John for many years now, and it's always informative, and as a civics teacher, really helpful to get the information, the content. I'm going to share my screen now, and hopefully everybody can see my screen. The Jamboard is a great place for you to give the feedback, and as we're going to talk a little bit about some of the stuff right now, it's great. As we first started, some of you guys were thinking about your classes that you teach, whether it's US history or civics or middle school, and how you could relate these cases and this content into those courses. As we were moving on, I know that many guys were watching the presentation, but you know, we had somebody talk about Asian American studies and through social justice and reading novels and the cases and linking this information to that. But I'm going to go to the last prompt, and then I'm going to kind of talk a little bit, and then we'll come back to the prompt. Thinking about the biggest takeaways from the presentation that we just heard, how would you use this in your classroom? And what goals and student outcomes would you use these lessons and activities for? Because we have a very diverse group in here, from the content teachers to the grade levels to the geography of your schools and the type of schools. With that being said, in California, we have state content standards. And as I was a new teacher, or when I moved from, I'm actually from Illinois to California, these are the standards I was supposed to teach to content-wise. And I'm just going to be honest, a lot of the stuff we heard today wasn't in those content standards. And that's not meaning that they shouldn't have been in there. They should have, right? But the state standards for content were not indicative of all this information, these content standards. I taught AP government for a while, and these are the court cases that are mandated by AP government. And you'll notice not any of the court cases we covered today are on there. That being said, the court cases are very important, specifically to our students. I teach Asian American students of various different parts of Asia, and I teach other students of other places. And a lot of the court cases that you're seeing here on the screen do not include cases that speak to our students. So getting the information that we did from John today about these different court cases would help inform me. And I'm going to say this, I was not taught about those court cases. And I know that my students are interested in the content and the information in those court cases. The next slide is the Common Core standards. And I think that now we're moving towards Common Core and teaching skills and teaching critical thinking, teaching evaluation, teaching evidence, teaching reading and writing. This information that you heard today is going to help you build those skills for your students and have the content to relate to that. And the next slide is, here in California, we have what's called the C3 framework. Me and John have worked a lot on civic skills, which, as you see here, you have the content, you have these skills, and then you have the taking action. And I think that as the kids are learning about the information that our students are learning about the information that we're talking about, whether it's affirmative action, whether it's voting, whether it's civil rights and civil liberties, they're going to want to not only use those skills, but to use it in the real world to take informed action and to speak out about those things, which I'll get to in a little bit. A lot of the resources that you probably come here for are available. Sandra I might speak to this, where you can get these resources online, but there's so much resources, and as a teacher, having these resources available to us is invaluable. And the 1990 website does a great job of it. Whether it is, you can search it. I just want to show you how you search it here. But whether it's the Chinese Exclusion Act, a lot of people saw somebody's teaching U.S. history about that, or whether we're talking about civil rights and civil liberties and teaching about that. There's so many tools here. And then another one I had is voting, right? You can search it and then find these resources there to help you really teach your students. But going back to our Jamboard, and I'm going to kind of open it up. How are you seeing that you would use this in your class, whether it's various social studies, various humanities classes, or otherwise? And how can we support you in taking this great content information and making it powerful in your classroom? You can write in the chat, or you can use the Jamboard. A lot of people, you're just swimming right now and you have so much information, but it is fantastic and informative. And I think the students would appreciate if the content really spoke to them more. And I think it did. I'm going to stop sharing my screen and maybe we can have hands raised. Is anybody raising their hands on how to do so? John, I guess we'll talk about this. You know, our students are interested in voting. They're interested in learning about affirmative action. How do you create a discussion using these court cases and get students to talk about the outcomes of the cases in a way that gets students to understand each other if they're from different places, relating civil rights from multiple different groups and voting from multiple different groups, and getting students to really think about it, but then be able to write or speak or discuss?
Thank you, Adam. I would say in a couple of ways. One is to have some of the understanding and information about the cases, to show that while a young person of Asian ancestry, a new immigrant student, a young person is there, they also bring this history with them. And second is for students to be able to see young people who bring cases and go all the way through the courts. You have 8-year-old kids and their parents going all the way to the court. So it shows to them that they can have that voice. One of the cases on your list of approved Supreme Court cases is Tinker versus Des Moines, the high school students whose student newspaper went all the way to the Supreme Court. So there are a number, I think, for students to see the law is their law and that they can challenge, they can use the courts. I think that's an important lesson. And finally, you have students who are going to be applying for college, and the affirmative action decision will have a direct effect on them. Now, of course, because it's controversial, bringing controversies into the classroom, it takes special care by the teachers to be able to have a discussion where one group of students is not pitted against the other, and to allow all voices to be heard. But it's very clear that people's lives, whether it is on post Roe v. Wade or potentially on the cases that I've described today, the courts and the law and the legislatures are affecting their lives, and it's important that their voice be heard as well.
Let's throw it over to I think it's Barbarina Davidson. Would you like to unmute and come on in? Yep.
Yeah. Where I teach, we don't have a separate government class, so I have to incorporate that in the world history. And when I teach, I have to explain to them why something is happening. So if there's a mass exodus of a specific cultural group, there has to be a reason why. So I have to explain to them and teach them why a group of people are leaving their homeland, what's happening in their homeland, to explain why they're leaving. So they have to be able to tie that into the reason why they're coming here. So once they get here, they're starting all over. And when you have a mesh, and then you have to explain the meshing of cultures. And and what they lack today is a sense of empathy. And so I have to get them to think about how the people themselves would have felt coming to a new homeland and being introduced to different cultures. It would be a big shock. And I try very hard to get them to envision how they would feel seeing a completely different landscape. And I have them do assignments where they have to envision themselves being there for the first time, just to get them to put themselves in that situation, just to get them to link with that empathy, which, you know, with all the attacks that have been happening, it's a good way to get them to become more culturally aware. These are just small things I do just to get them to become more aware and more, I guess it would just be more of human, because a
Yeah.
lot of times they just don't, you get people who just don't care, and that's the way to get them to care.
John, I mean, I as a person who teaches in classes, and you need to have the content reflect the students, but then students really care about the people in the classroom and learn about each other's stories and past and struggles. And this helps arm us as the teacher to have that content information. John, and then I was going to do another question out of the chat.
Marina, thank you for those comments and your experiences from the classroom. It's really important, and I think asking students to envision what it would be like, either maybe because of a natural disaster or something else. What would it be like for them to immediately have to leave and move to another part of the U.S. and then what would it be like for them to move to another part of the world? And just think of the day-to-day things that would change in their lives, whether it's their language or whether it's the system of travel or communications. All the type of things we take for granted here don't exist in another country. Not because they're less, but they're just different. And then say this is what people coming here have to go through just to catch up to where you are. I think that would be a useful exercise.
It just seems because of all the school event things that happen in schools of late, the students have, as a safety feature of their own minds, have become desensitized as a way to protect themselves. And I don't fault them for that, but you have to keep trying to keep that sense of empathy without them breaking down, if that makes sense.
I'm going to go on to one of the other questions. I think that was a really great question. Another one's about teaching court cases. They're dry sometimes. There's a lot of jargon in that. How would you teach middle school or high school students these cases and make it engaging and make it accessible for all students? And are there any resources that you recommend that teachers use to do so?
PBS has a lot of stories about Asian American history and some of the cases that I talked about. I think always bringing it back to the theme of just stories about students, young people. Wong Kim Ark, when he brought his case, he was 22, not much older than a lot of the high school students. Another case is celebrating a milestone, the 100th anniversary of Meyer versus Nebraska. And Meyer versus Nebraska was brought by a 5th grade teacher and his students in 1923. In this case, it was German American parents who wanted their kids to learn German so they could teach Bible lessons to them at home. And that case went all the way to the Supreme Court because Nebraska barred German from being taught in the classroom. That case now provides the support for bilingual services as well, because the U.S. Supreme Court in 1923 said the Constitution, protection of the Constitution extends to all, whether you know English or not. So having cases of kids in the Constitution, I would call it, and just emphasizing that there are people, average students, parents, and community members are involved in these cases. Like telling the story, there are a lot of resources that are out there that simplify it into the story, and then you can add on the legal propositions.
Yeah, and I shared the screen below, but these are some resources that I don't know if, John, you shared, or the 1990 Institute, which has each of the court cases that you talked about today, some lesson plan guides, some videos and whatnot. So there are a lot of resources out there, and I know that the 1990 website has a lot of stuff that you could do that. The other question I got, which is more of a civics question, is about voting and getting young people involved in voting. Whether it's for a new political party, I guess this week Andrew Yang and came up with a new political party, a third party. And if your thoughts on that and getting young people to vote, with seeing a party that represents more of their beliefs, or just getting students to vote in general. You talked about the laws. How would you talk about voting in class and get young people engaged in the voting system?
Ironically, Adam, one of the other issues that you and I work on, lowering the voting age to 16, both the California and the New York cases probably have put that movement back a long way, given what the state constitutions say. For California, at least, people who are going to turn 18 before the next election can vote, so they can have voter registration campaigns. But I think what's more important is not only just voting, but how students can get involved in civic engagement in general. Because obviously, because you don't want to exclude kids who are not citizens in these lessons about civic engagement. There are plenty of opportunities where students can identify problems or situations affecting themselves or their families. Sometimes it could be relocating a school, a bus line that serves or doesn't serve the school well. There's something, and students can go to a local government agency, the city council or some commission, to advocate for that. I think being able to draw a link between a problem that students see every day and the notion that they actually can do something about it is the way to empower them and then inspire them.
I think that's a great point to end on there, John, is that the historical context you just gave in that content, and whether you're a U.S. history teacher or your history teacher or you're a teacher that teaches any subject area, giving that information, then having students learn the skills of evaluating what was going on and at that time period, and then today, and comparing and contrasting with then and today, and then making informed action, right? How do we get young people to vote? How do we get young voting rights to be really maintained for young people and other people, and the suffrage that's available? And I think that that's the important part of a teacher, is to take this information that you just laid out in your lecture today, but then have students wrap around it and then be able to do something around it and be informed young people. And thank you for that, John, to kind of make those connections for us today. I'm going to throw it back over to Sandra, who's going to close things up for us.
Thank you very much. Gosh, that was so much information that we're absorbing today. And I really appreciate all of you staying with us to the very end. A couple of reminders. We have 2 generous partners that are donating books for us. And that information is all in the, again, the Teachers Workshop portal. You probably hear us talk about that so many times. And we want to thank you also for following us. And we're available on all these different platforms that will always give you additional information of things we're doing, programs we're producing, assets that we're putting out that you can use in your classroom. if I may give you one more look at our website, and this is the portal that we have created for you, and in the teachers resource segment, you will see we will populate all these links for you shortly with the presentation that will have resources. Again, please fill out the speaker feedback form so that we can improve upon what we're doing. Under the resource tab, we have three channels. One is on the programs that 1990 is producing. We will also have a channel on Asian American resources that builds on video, podcast, books, website, lesson plan, activities. You can take people on field trips. What I neglected to say earlier is the Asian Art Museum will be able to do special classroom visit as well as we will have the same thing on contemporary China. And finally, if you're looking for previous recordings of what we've done in other TW workshops in the past, it can be found here. Again, thank you so much for all your attendance. We really appreciate it.